SJ, welcome to Mvskoke Radio, your weekly source for tribal and community news, interesting guests and discussions, plus a local events calendar. Nation sense, but in personal ownership. We have folks from the Realty Trust Services who will be sitting in here first. We're going to talk about some of the knowledge you probably need for your restricted lands and the issues that are there. And then later on in the second half, we have a discussion with our Attorney General, Roger Wiley, and our host for our TV components, the Mvskoke Radio producer, Jared Moore, talking about some of the questions going back and forth between the administration and the National Council. So you might want to check in on that because it might really affect you. Okay, first of all, let's do this. We want to welcome Rachel Langley and Sonia McIntosh from the Realty office. Good morning, welcome. Let's try that again. Turn your microphones up. Anyway, good morning.
Good morning.
All right, there we go. That sounds better. I'm hoping. Now, the mission that you all have is such an important one for practically all of our Mvskoke Nation citizens. If the landowners don't really know what all of the items and restrictions are, this is a good chance to find out today. We'll be talking with them, and they've got a seminar coming up early in July that will discuss all of these topics, but we're going to give you a bit of a preview here today. Now, first of all, we would, of course, like to ask the same question we always ask of everybody, and what does your office actually do? What is your mission and purpose in serving our Mvskoke citizens?
Okay. I'll take that question. The objective of our office is to provide recommendations related to the services of our individual landowners. Our office maintains a little over 100,000 restricted acres that are owned by individuals. So that's quite a bit of land. We like to pride ourselves that the creeks have kept their land. Mm-hmm. We've kept it in restricted status. So our office maintains that. We have a trust responsibility to them. So we maintain trespass issues, right-of-way issues. We are the fiduciary responsibility for them. We make sure that they have good leases, they have good title, and basically just help them with their any land issues that they may have. So when we were talking today, we really encourage everybody to come to our presentation that we're going to have at River Spirit on the 7th, which is part of the intertribal conference that they're having there that week, the 7th, 8th, and 9th. So we'll discuss all these issues, and if any of our landowners choose to come, then they can listen to us in a presentation forum, or we'll have our laptops and all of my staff will be there and we'll be set up and they can come to us individually, and we'll have access to different files that they can talk to us individually. So if they have any issues, then we can discuss that there at that time.
All right. Now, this is set up to serve the rank and file citizen and not the government. It's not a question of sovereignty, and the McGirt decision does not figure into much of anything that you all do, right?
Right. What we're doing with, as far as the McGirt, our office is just verifying jurisdictional boundaries. Mm-hmm. So that's pretty much all that our office has done so far as McGirt.
Okay. Pretty nice saying that's creek land.
Right.
Or as we've renamed ourselves, that is Mvskoke land. Okay, thank you. Now, Rachel, you have a special duty within the office. What is it that you do?
I'm actually the TAMS coordinator for the office. And TAMS is Trust Asset Accounting Management System. It's a system for land records that the Bureau of Indian Affairs uses nationwide. Basically, I can look up individuals by their name and see what lands they own, not only in our reservation, but anywhere within the nation. Any other tribe, if they have interests or anything like that, I should be able to look up what leases they have, how they inherited, just any title issues that they have.
Okay, now say I had some, well, actually I do have questions. I do own some land down near Bristol. And you would be able to answer the questions that affect our holdings here, our family holdings, right?
Correct.
Okay, so if I've got a plot down there and somebody wanted to swap out and exchange it, that's not something I'm interested in, but what would be a procedure if somebody wanted to change an ownership like that, restricted to private ownership like that?
Well, if it's restricted and you have inherited it through probate, most of those actions, conveyances, probates, leases can go through district court or do go through district court. So, for instance, if you wanted to sell your interest in your restricted property, what happens in that case is you find a buyer. The buyer actually pays an attorney, their own attorney, to petition the district court where the land is located, which in your case would be Creek County. When that attorney petitions the court, we get notice and we perform an appraisal to let you know what that property is worth. We don't give that to your prospective buyer. That is just a beginning point for price. For instance, if they offer you $100,000 and it appraises for $50,000, well, great for you. You don't have to tell them what it appraises for. We don't encourage the sale of restricted land, but if you are going to sell it, we always want you to get the maximum dollar amount for that. So once we get the appraisal, it actually goes to court. The Tulsa Field Solicitor's Office would represent the restricted landowner in district court proceedings. The restricted landowner would not have any cost associated with that. The buyer pays all attorney fees, any abstracting, title, or anything like that. The buyer is responsible for all that, and you would actually get paid in court the day that the deed is approved.
Would that include something like having it surveyed?
Yes, sometimes we do have to have a survey. For instance, if it's 40 acres, that's a pretty easy legal description to do. But if you just want to sell, let's say you have 10 acres and you have 4 children that you want to give 2.5 acres apiece to, you want to go ahead and divide it while you're living so they don't have to mess with probate. We actually do provide that service for our restricted or trust landowners to help divide that.
God, that's so satisfying to know that this kind of information is available through you. I had a guy who wanted to buy my land. I said, no, I'm not interested in that. But it made me stop and think, my God, there are so many questions here and tied up in legalities because it's, restricted land and versus non and blah, blah, blah. That I was, kind of staggered by the thought of it and all of the steps you have to go through. And it's not a matter of just going down and swapping titles. It's this.
Right. And that's kind of a misconception, especially with our restricted land. People want to just go sign a deed and get paid. And unfortunately, well, I say fortunately because there is a process for that. And the reason that I love the process for this is because I know everyone has heard back in the old days, great-grandpa didn't know what he was signing, signed a deed for a horse, and he sold his whole 160-acre allotment. Well, after the, we call it the 47 Act or the Stigler Act, which was effective August 4th, 1947, it made those leases and conveyances and probates go through district court. So it's a safeguard for our restricted landowners. Yes, sometimes it can be a hassle if you're trying to get something done fast, but it's also a safeguard. And it helps us oversee, as a trustee, helps us oversee and help protect your asset.
Okay, that sounds like a wonderful, as you say, safeguard protection for creek landowners. Now, excuse me, Sonia, now, how many cases do you all handle in, say, a year? I mean, is it a lot? Is it a lot of transactions? What have you got?
Yeah, right now we are, with COVID, we still continue to work. Obviously, we are handling over 400 right-of-way issues. We are handling, we do reports for distribution, which are the end of a probate. I like to say we do the beginning of a probate, which are the inventories for the attorneys for a probate. We have
Close to 300 pending inventories right now.
Wow.
and so we have that's the beginning, and then the end. I can't tell you the exact figure, but I know that for 2020, I think the figure was close to 50 that we completed during COVID while my girl was sitting at home working. So it's pretty good. Leases, we do pretty much the biggest amount of leasing of our restricted farming and grazing and business leases of the 5 tribes. So because of our large land base, and that's for individuals. So, we're pretty proud of that. So we try to get the biggest return that we can for our landowners. So that's what our job is, and that's what we have to do. On top of that, like she said, we also provide the service for individuals to put their land into trust. None of the other tribes are doing that right now. For individuals, we also put land in trust for the tribe. We also do the surveys. That's a free service for our citizens. Appraisal services. We've compacted that function, LTRO, and we have a fencing program now. So we do a lot. We do a lot in our little office. So hopefully, we just continue to grow.
Mm-hmm. Well, I got several flags went up for myself personally, and it's like, okay, surveys, protection. We're going to try and keep this simple. I mean, I looked at this and saw all the legal terms that are involved here, so you'll have to forgive me for asking very simple questions, but I'm sure there are other listeners who might want to know some answers too. Now, when we say inventory, what does that mean? What does it include?
Okay, so when someone passes away, a probate needs to be done. A probate is actually a legal determination of heirs, and until a probate is initiated, the estate essentially owns the property. No title has been changed, even though we probably know that it's going to go to their children and spouse if they had one. No legal title can change until that probate is actually started. So when an attorney requests an inventory is a list of all the restricted assets they had. Let's say they had 4 grandparents that were original allottees, and they owned surface in 2 and minerals in all 4. We would provide that to that attorney so they can list that to change title within that probate case.
Okay. Now, excuse me. The challenge, and I've gone through the probate with my father's holdings, and when he passed away years ago, and I'm just so glad that there was an attorney there that could speak plain old English and take care of our matters in a really efficient manner. So I was, just delighted with whoever made it happen. I presume that was your office?
Well, the tribe actually does do, they have a service, the Creek Nation Legal Services.
Mm-hmm.
And there was such a great need back when, and I'm sure everyone has heard the Cobell settlement.
Mm-hmm.
Cobell settlement, they would not pay out to estates, so they had to have the probates done. So we got really backlogged with that. So the tribe actually started contracting private attorneys to handle those probates free of charge for our Creek citizens. Now, you do have to make an application with the legal services, but that is a wonderful service provided by our tribe.
I'm curious now how much of Creek land is remaining in trust. Is it a shrinking amount? Is it stabilized? What amounts of land, I guess maybe is what I'm asking.
Well, in restricted land, we have approximately 128,000 acres that are owned by individuals. For a while, it was shrinking rapidly because that act of August 4th, 1947 had a requirement that you had to be half-blood or more of the 5 civilized tribes for their property to remain restricted. So once the heirs fell below half-blood, that was no longer considered restricted land. Our office was in part for the amendments, what they called the Stigler Act amendments that went into effect December 31st of 2018, that took away that requirement. You only have to be an ancestor of someone on the Dawes roll by blood of the 5 civilized tribes to inherit now. And that has tremendously slowed down losing the restricted status for people.
That's good news. I mean, we lost so much of it. The reason I bring that one up is currently they're in production up around Pawhuska on the Killers of the Harvest Moon. It's where Osages were being murdered for their lands and the oil leases, and you got non-native people who made themselves billionaires after that ridiculous, murderous event. Now, have our Creek people ever faced that sort of threat, I guess you would call it, from the outside, that you can recall or are aware of historically?
I don't recall personally seeing anything like that. I mean, any mass events like that. However, there are the stories of Grandpa signed over all his allotment, for money to feed his children, and it was, meager amounts of money, or for the horse, or something like that. So I don't know.
No, in saying that, though, I think, like I said earlier, I'd just like to repeat and that our resiliency with keeping our restricted land, and when I say our, I mean the allottees and the landowners that we have currently. That's why we have such a big land base. Our landowners, they didn't probate. They waited for that Stigler Amendment. They waited for December 31st, 2018. They kept it in the allottee's name, or they knew if they were going to be less than half-blood that they would not inherit in restricted status. They just waited for that amendment to happen, and we had a lot that did that, and that's to be admired. So, and now since that amendment happened, now we see that uptick in the probates. So, and they are now inheriting in a restricted status. So it's to be admired, and that's just shows that they had faith in the last group that went in front of Congress was a group of Realty people. There were attorneys involved, but there was a group of Realty people that pushed that amendment, and Rachel and I and other Realty people and people from, we were honored to do that. But it was really a great thing that our people waited to probate. So, and now our land base is only going to get bigger. There was another amendment in there that you can buy. So it's really good. It's really it's really good for all of our landowners now. So I just admire that they held on to it for so long.
Right. While you were responding there, when something popped up now, Is it easier from one creek person to sell that land to another creek person? Is it?
Yes,
The
and
way
that is another provision of the Stigler Act amendments. Before, and I'll just use you as an example, if you wanted to sell your interest to your brother, when your brother paid money for that, it became unrestricted. With this amendment, now you can sell it to your brother, and it still stays restricted as long as it is to another 5 civilized tribe bloodline member.
Okay, you hear that, Vic? You can't do. You got to come talk to me first. Now, you've got a number of intriguing-looking topics listed for your presentation. Among them are trespass issues, of course, probate, rights-of-way, leasing, petitions, and quiet title suits. So let's pick one of those and spend a minute or two kind of dealing with it. Now, say something like rights-of-way. If the state wanted to expand a highway and it needed part of what you've got, what happens there?
So rights of way can involve highways. Obviously, ODOT, or Oklahoma Department of Transportation, is pretty familiar with how to do their part now. They would contact our office and get a package. Part of that package to submit to us is a survey, how much they are offering, what exactly they are putting there, and when they submit that application to us, we contact the individual landowners and say, this is what they're offering, this is what they want to do, are you in agreement? That's the starting point. And if they say, yes, that's fine with me, but let's negotiate for higher. We have a girl in our office that is really good at negotiating high price right-of-ways. And so we do the whole process from application to completion. We make sure they actually do what they're supposed to do, and we have an inspector that goes out and makes sure they're all along, that they're doing what they requested, and that they are only disturbing the land where they did that application for. Now that's for say highway expansion, but we also do electric lines, water lines, sewer lines, fiber optic lines, gas lines, all that kind of stuff are also considered right-of-ways.
How about a situation where there's a piece of Indian land surrounded by land owned by non-Indian, and you wanted to get access to your allotment there? How would that happen? Would you come, first of all, they would come to your office and kind of work it out, or could that be a deal between the two individuals?
I'll let you
Well, when it deals with restricted land, they always need to come through our office.
Okay.
It's imperative that they do that. They don't always do that, but that's why we have these presentations, and we try to get out into the public and talk to as many landowners as we can, to let them know that that our office exists. A lot of people still don't know to this day, especially new landowners that have recently inherited. They don't know. They know that we went to probate court and we've inherited, and now we can do whatever we want to. So we try to have these meetings like this. This is going to be one of the larger ones, but if we can have it in a smaller venue, we try to do that. So So anytime it involves restricted Indian land, we really try to get out there and let the landowners know that we are here, this is where our office is, you need to come talk to us first, and try to do it the right way so we don't have problems later on down the line.
So even if you're not sure of what you should do, they should probably get a hold of you and ask.
Exactly.
Right. All right, well, we've only got a little bit of time left now. If someone was interested in getting information for themselves alone, or attending the Realty Trust Services seminar you've got set up, how do they get in touch with you?
Well, we would like them to call and pre-register, just so we know how big of an area that we need to reserve. Right now we are able to accommodate 200 people, so I think think we have close to about 80 that are pre-registered as of today. But if they will give us a call in our office, it's 918-732-7713. That's our main Realty line. And when they call, they simply need to tell us their name, a good phone number, and then how many people they're bringing. We ask for the phone number just in case we need to change rooms. If we need to get a larger area, we will call everyone the day before to let them know where we would be changing, but hopefully we won't have to. The River Spirit Casino and Resort, we are going to be meeting in meeting room 1. Let me give that address just for anybody that does not know where that is. It's actually just off of 81st and Riverside. The address is 8330 Riverside Parkway in Tulsa. And again, that's in meeting room 1. And to pre-register, please give us a call at 918-732-7713.
Okay, and bring whatever information they've got.
Yes, we will try to address individually. We're going to have tables set up at that meeting so we can address individual clients, and then also we're going to present an overview. We may have questions come up that you didn't know that you needed answered.
Okay. The date is Wednesday, July the 7th, from 1 to 3 p.m. at the River Spirit Casino and Resort. So if you've got questions, if you've got a situation maybe that you're dealing with, you might need some guidance, you want to attend this session, it's 732-7713. Sonia, Rachel, thank you so much for being with us, and you've actually answered a few questions that I have, and may have to take some time and come visit you at this presentation.
All right. Thank you for having us.
Thank you.
Okay. Now, we're going to take a minor pause here, and then we're going to be back with our discussion from the Attorney General regarding some questions that have been floating back and forth between the National Council and the administration. So please stay with us here on Mvskoke Radio.
Your kids. Keep our culture alive. A message from the Partnership for a Drug-Free America and the National Congress of American Indians.
Learn more at ncai.org.
Okay, we want to share a bit of a discussion between Jared Moore, who is heading up our video section at Mvskoke Media, and our Attorney General, Roger Wiley. Now, it's been rare occasion when we've got an Attorney General to speak with the media, but we thought this is worth sharing, and for the information our citizens could certainly use. So once again, thanks to Jared Moore. Let's listen to him and the Attorney General.
Welcome everybody to LiveWire. Today's program, we're going to have the Mvskoke Creek Nation Attorney General, Roger Wiley. He's going to be talking to us about some legislation that went through the council at their May 22nd session. And we might touch on some other topics. If you are a citizen, you have a question for the AG, we'll try to ask it just put it in the YouTube chat. We'll try to ask it, see if we can get an answer. That being said, thank you so much, AG Wiley, for coming into this LiveWire. And I'm just going to dive right in and start off with, on May 22nd, the National Council overrode a veto from Chief Hill concerning NCA 21-045, which appears to give councilmen the ability to request personnel documents and other documents directly from department heads. My first question would be, were you involved in the crafting of this legislation in any way, or did you have any input when it was being going through committees and things?
Well, I was provided a copy of it and was asked if I had any issues with it. And the issue I had was with, I think it was Section 9104D originally, which provided that no records were confidential. And so I suggested an amendment to that at the BF&J meeting to eliminate that paragraph, and it was eliminated at the meeting. There was a mix-up, and somehow the wrong legislation that left 104D in the 9104D in the legislation that was sent over by the council to the chief's office for signature when it should not have included that provision. My understanding is 9104D has been since eliminated and the correct version of the bill has been signed into law. So that was most of my involvement with that legislation.
Well, and just for the audience, currently how you would check to see, and this is a topic we might touch on in a few minutes, but how you would check to see what code is out there is you could go to the creeksupremecourt.com, which has the Creek Nation Code and the Constitution on it. They have not updated their code page yet, just to give you a heads up, Mr. Wiley, that with this particular law. So if they've actually changed that section D we were just talking about, if it's been changed, I don't know for sure, because the veto override copy of legislation that went through the council on the 22nd session had that section in it, just to give everybody a heads up. So we don't know for sure what they have or haven't done, because it hasn't been officially published anywhere yet. But there are also some concerns in Chief's veto message. Were you involved in the crafting of Chief's veto message that he submitted?
No, I was not.
Chief's veto message also outlines that the National Council's investigatory powers were limited, and he's referencing Ellis versus National Council SC 05-03/05. He says that the NCA 07-191 recognized that the National Council's investigatory powers were limited to validly issued subpoenas, and the law also provided due process protections to employees and citizens recognized, and the principal chief and second chief were immune from the law due to executive privilege. Would you agree that those things would hold for 21-045?
No, and I don't. No. Well, I don't understand your question.
Well, my question is in Chief's veto message. He says that after the Supreme Court case Ellis versus National Council, right? There were a series of NCAs that were passed to try to remedy the situation that occurred in that case. And one of the things that passed, the NCA 07-191, basically said that the National Council has a method that if they want to get information that they can use, which is they can subpoena people to their investigatory committees or any committees and have them come in and give their testimony, right?
Right.
And then it also, that particular NCA also said that there should be due process for any employees and citizens that should, and really that should go without saying, they should have due process in their if they're going to be requested to give testimony. And then principal chief and second chief are exempted from any of that due to executive privilege, like the federal government idea of executive privilege, where the executive can say there is certain information that happened while I was doing my duty, and I can't give that to you, right? If that makes sense. So with the passing of NCA 21-045, though, does executive privilege apply to that, right? What in NCA 21-045 protects the due process of citizens? Or I guess my question is kind of, why was this law, what do you think is the purpose of this law for the council? Why did they need this? Why did they need more than a subpoena is my question.
Yeah. Well, okay, we'll start. First, I think it was a bit of a cry into the wilderness for help, because I think the council believes its legitimate request for records was not being addressed. Now, the part about the subpoenas, and I'm reading directly from the chief's veto message, NCA 07191 recognized that the National Council's investigatory powers were limited to validly issued subpoenas, and I disagree with that. I don't think it is limited to validly issued subpoenas. And let's think about that. We are running a dysfunctional government if we require one branch to get a subpoena before it can obtain simple records from another branch. Say there's a financial document, or there's a question about how much a vendor is charging. Why would we have to go to court and get a subpoena to get that information? I believe this government should function in a more cooperative manner where subpoenas are not necessary. I don't believe the Ellis case requires subpoenas. And I think the tone of the Ellis case is cooperation and balance among branches of the government. So as far as the subpoenas go, I couldn't disagree more that you have to have a subpoena to get records from one branch to the other, chief from executive or executive to legislative or vice versa. So anyway,
as devil's advocate on that particular argument, what if we had a scenario where a councilman went to a department head or what the individuals dictated in NCA 21-045 and they said, for instance, I want a particular employee's employment records, right? Like, give those to me. Would that be violating the employee's due process or their privacy requirements or anything like that? And could that happen under NCA 21-045?
Well, sure, it could happen under NCA 21045. The due process protections, I think, in that legislation are provided for in the penalty provision. 9104G says that the same penalties referenced in FOIA, the Freedom of Information Act, shall be applicable, and that has some provisions for due process under FOIA. So, and if there's a problem with that form of due process, then FOIA has a problem with its form of due process as well. Any law can be pushed to an extreme, and you can act in an unconstitutional way under that law. That always has to be recognized. So, it can be taken to its extreme to answer that question. Hopefully it will not. Hopefully the two branches will cooperate and records will freely be exchanged as needed for legitimate purposes.
I see. So, Chief's veto message declares that, in the executive's opinion, that it's an unconstitutional law. I guess another follow-up question to that would be, is this going to be challenged in district court? Are you going to be going into district court over this law and trying to get, or going to the Creek Nation Supreme Court to get a determination on whether this is unconstitutional? Isn't that how the process would work in this situation? Is that if the principal chief believes that a law is unconstitutional, they've override his veto, he should go to the Supreme Court then, right, and have the Supreme Court do their interpretation? Am I correct in that?
Yeah, well, you could do that and ask for what's called a declaratory judgment, where you have a question and you want the court to determine the right answer for it. Normally, though, you have to have a case in controversy. You have to have a party that's aggrieved because, say, the council comes to them and requests records that should not be released or are confidential, and they try to put pressure on that employee or that particular branch of government and try to impose some sort of punishment. That would create a case in controversy. Ideally, you want to have a case where there are issues, potential punishment, and you would ask the court to decide that. Now, but you're right. The chief's office could take it to they take it to the district court first for a declaratory judgment, asking the court to declare whether it is constitutional or not.
Okay. I don't know if you're aware, because I was assuming that you would have been involved in the veto message, but so the veto was overridden in May 22nd. On May 24th, Principal Chief sent out a memorandum to all cabinet members and executive branch employees, and it's in the video description link for the audience if you guys want to take a look at it. Basically, the gist of the memorandum, and I'm going to read the last paragraph that was highlighted by the Chief's office. It says, as a result, NCA 21-045 will not be enforced or recognized as valid law by the executive branch. All cabinet members and executive branch employees are to respond to information requests from the National Council members in accordance with previously established executive employment policy on legislative branch requests for information/correspondence. Section 503 of the Human Resource Policy and Procedure Manual. Are you familiar with this memorandum?
I've read that memo, yes.
What is your opinion of the memo, and were you consulted on it? Did you have any input on it?
No, I did not. Well, I'm concerned about that memo. I think anytime an elected official asks someone not to follow the law, that's a problem, and the law hasn't been set aside as unconstitutional. So yeah, I do have a problem with that approach. It should have been challenged if the claim is that it's unconstitutional. And here's my second problem with it. I mentioned a while ago that the punishment for the Records Act, as I call it, it's the NCA 21042 that we're, or 045 that we're referring to. As I said earlier, it relates any civil penalties referenced in Freedom of Information Act shall be applicable to this act. And one of the provisions for penalties in FOIA is G, any elected or appointed official or any exempt employee who orders or otherwise directs an employee of the nation to violate the provisions of this act shall be subject to a fine, and it goes on. That's the danger. I don't think anybody should be telling someone not to follow the law, and until it's been challenged and set aside.
Yeah, the memorandum kind of creates a situation where the decision making on that particular process has to happen for the employee who's approached with the request, right? Because their boss is telling them don't honor this request, and there's, just like you pointed out, there's civil penalties if they don't honor it. And then so how do we get out of this situation is because now you've got employees are going to have to make a determination on what, pick your poison.
I know, and that's unfortunate. And what I see is two branches of government clashing and the employees being stuck in the middle, and that's not good for the employees. They need their jobs. They don't want to put themselves in a situation where they could lose their job because they think they're following the law or because they're doing what their supervisor told them to do. Yeah. This needs to be worked out. We need some sort of meeting to freely exchange documents between the executive and legislative branches so we can pass laws and enforce laws and make sure that we are operating our government in a cooperative and functional manner. Because, right now we're under a lot of pressure and a lot of people are watching us, my office in particular, for law enforcement and prosecution. And, that has to take top priority. And
absolutely,
we need to act in a manner that is reflective of strong government. And when we fight, we're not acting in the right way.
Yeah.
And so I feel badly about the position it's put the employees in. Yeah. And I think something needs to give here.
Yeah, absolutely. Well, and you bring up another point about, and I'm assuming you're referencing the caseload from the McGirt decision.
Yes.
I just wanted to check in with you. Is your office getting everything you need? How is the process going? Is everything flowing through the courts? If you could give the citizens just kind of a status update on the caseload.
Well, the caseload is tremendous. It's we calculate that we filed over 1,800 criminal charges since McGirt was decided July of last year. We don't always get the records we need. Sometimes the jail logs are slow and the booking sheets are slow to get to us, and those are important because we need to make sure that someone has their appearance and bond is set right away so they don't sit in jail. We're working a lot of these things out. This is new for everyone. It's new for the other tribes too, who've had similar rulings since then. We're going through some growing pains, but like I said about the two branches of government, we've got to cooperate, and they've got to the counties have to cooperate with us, and we've got to cooperate with them, because it's all in the best interest of public safety. We're all sworn. Our sworn duty is to protect public safety. That goes for law enforcement officers. Courts are sworn to give fair trials to anyone who's charged with a crime. And, we can't do this unless we work well with the counties and the cities and the federal government. So, I think we're doing pretty well. It's a tremendous amount of work that we've undertaken, and it costs a lot of money. And we're going to have to look at jails. We're spending a lot of money on our jail agreements with the other counties. So we'll have to consider whether we want to build a jail or build a juvenile facility for juvenile lawbreakers. These are kids who commit serious felonies, who you can't just send back home to their parents. Mm-hmm. We have to have special, jail accommodations for them. Those are all issues we need to work out. It's similar to the saying, how do you eat an elephant? one bite at a time. We
Yeah.
just work it out as we go.
Yeah.
And I'm proud of our crew here. I think they've done a tremendous job.
We've got some questions that have popped into the chat. I just want to try to go through them.
Sure.
The first question is, what is the status of the Kyle-Lee/Bruner casino case? I know that and this is some time ago for the audience, right before the previous chief election, there was further charges filed against Mr. Bruner in the court about conspiracy. Do you have a status update on that, or maybe what your office is there's going to be any pursuit of that, or where are we at with that?
Well, that case, there was a mediation conference between the parties. They had, some issues with us that they were taking to court, and of course we had issues with them. We ended up resolving everything based on a unified resolution. We dismissed the charges based on issues we had with evidence, and they in turn made agreements with us not to pursue any civil litigation, and the case, it was time to move on from that case. We did not have the type of evidence we needed based on some issues that I'd really rather not talk about, but that case has been resolved and dismissed.
Okay.
That's where we are.
Well, and for the audience, if you go back in our coverage, you can see some of the issues with the evidence that AG Wiley is talking about. The next question from the chat would be, does the Oklahoma Turnpike Authority actually have the authority to impose tolls on Mvskoke citizens for their travel on such roadways inside the reservation boundaries?
Well, again, like everything else I've said up to this point, until a court determines otherwise, yes, you do. And I pay my fees and, toll my pike pass fees too. So unless the court tells you otherwise, and they're not going to let you cross that highway or use the turnpike, I should say, if you don't pay them. So as it now stands, yes, we do have to pay those turnpike fees.
Okay, we got another question. Are you willing to discuss Article 2 of the 1866 treaty?
And what is our, okay. We've got litigation pending on that.
Okay, all right. We've got litigation pending on that, so we are not.
And I think anybody can read it for themselves, and it says plainly what it says, and that's why we take the stand we take, because we are enforcing the terms of that treaty.
Right. Okay. One more question. What are your thoughts about the recent announcement made stating that the Mvskoke Nation will begin discussions about about freedmen's citizenship? How do you see your office participating in that process? Just for the audience who might not know, there was a news program, I think it was Channel 6 or Channel 8 locally, that had did a segment about I believe it was close to the anniversary of the Tulsa Race Massacre, about the freedmen issue with various tribes, and it got quotes from various tribes, and the quote they got from the Mvskoke Creek Nation was along those lines, that we're working to resolve this issue or something. Do you have anything to add to that, sir?
No, I don't have anything to add, and I would leave that up to the chief's office, because they made those comments, and so anything to follow up on that should come from the chief's office.
We have a follow-up question on the tolls. How would a citizen challenge the tolls? Could they challenge them in court?
Sure, you could take them to court and say, I shouldn't pay any turnpike fees because I'm a Creek citizen and this is located exclusively in Creek land. I'm trying to think. I guess the Mvskoke Turnpike would be exclusively within the Creek Nation, but I know the Indian Nation's Turnpike is not. Turner is not. So I guess that would be where your challenge would likely come from. If I'm correct about Mvskoke, and actually it goes into the Cherokee Nation as well. So
yeah,
interesting questions, interesting fact questions there. But it could be challenged the same, as any other law.
Well, I think we've caught up there on the questions in the chat. I have one more thing I'd like to talk to you, or two more things. And we kind of talked about this before we started streaming, but recently, Representative Scott was censured and expelled from the council and fined $40,000, etc. Mvskoke Media, at the time that press release was released by the council announcing that, we sent a request to the Speaker of the National Council trying to find out what was he charged with, what caused this, what happened. Basically, any information we could get about the situation. and we haven't received any response as of yet, and it's been a few weeks. Were you involved in that process, the investigatory hearing committee of that, or like, do you know anything about that situation at all?
Well, I was not involved in the investigatory process, excuse me. I do know something about it. The question is, can an officer of the nation do business with the nation? And of course, that's covered by our law. And I was asked, to review the law, but I did not participate in the hearings for fact-finding or internal affairs.
Okay. And then my final thing for today, because we're getting close to the 30-minute mark. So we were talking earlier about NCA 21-045 and how there were amendments done in the BF and J Committee, Business, Finance, and Justice Committee, that apparently did not make it to Chief's desk, and that's partially what resulted in the veto, right? And you were saying that you had been told that was going to be remedied. And so we run into this problem of if you're a citizen or you're a news gatherer like me, where can you go to get the official code? And I don't know if you're aware, sir, but in 2016, the council actually passed NCA 16-027. And what that did was it transferred the responsibilities for codification of the nation's laws under Title 30, Section 104. That Title 30, Section 104 is where it says that the National Council will make a committee that will be responsible for codification of the laws and publishing of the laws, right? They transferred all of that section's responsibilities to the Attorney General's office. Mm-hmm. So technically right now, and this, I don't believe that this has been amended. This happened, I believe it was Attorney General Dillinger was in when this happened, but at the time we did a news story on it because we asked him, and he said they were going to make a searchable database. The AG's office I'm referring to is going to make a searchable database. It never materialized. Were you aware that you're supposed to be publishing the code?
Yeah, I am.
Where are we at on that? Is that going to happen? Because just for me, and I know for other citizens who are interested in the legal stuff that happens at the tribe, it's like because the Supreme Court isn't required by code to publish it, they don't have to keep up on it, so it's like in situations like this, I'd like to know what's been codified, and we don't know. So any information you have about that?
Yeah, I'd like to know what's codified too, and that's the problem. I was aware of the legislation you speak of, and Kevin Dillinger was the AG at the time, and since I've been here, it's been all gaming compact lawsuits and McGirt. And I'm not making excuses. I'm just telling you my focus has been elsewhere. I'd like to see, we need desperately to update our code in the worst way. I think to answer your earlier part of that question, how would you find out what's in the code or not? One way would be to call the council clerks and ask them for the most updated version of the code. And I think you could do that on 21045. Okay. They sent me a copy of the page that had been updated, removing 104D or 109.4D. So you could probably get that from them. But we need to update our codes in the worst way. And I think I would like to see that legislation addressed and perhaps let the Supreme Court deal with the codification issue.
I see. Okay.
Because quite frankly, I don't have the time to attend to it.
Yeah, and absolutely.
And it's a massive undertaking.
It is. And it's something that even here in-house, we try to do as much as we can, because for us, an important thing to have for the reporters that are going to do basically any type of legislative coverage or legal coverage is to have something you could go into the code and search it, because I was compiling it myself by getting the PDFs from the Supreme Court and putting them all into one document. It's like at 800 pages or something at where we are now. It's thick. So, so that's good to hear. And any legislators that are listening, there's the AG saying we need to fix that problem. So it does raise an interesting question, and we're almost. Oh wait, let me look at the chat. We have We have another question. Let me see here. Do you think allottees who are criminally abused and exploited should receive reparations? Oh, sorry. He does a correction here. Descendants. He apologizes. He says, I mean descendants.
Allottees. Do I think they should be paid for reparations? Well, I'm a descendant of 2 allottees, so of course I'm for it. But I don't know that would ever be accomplished.
We got one more question. Can the tribe seek justice on behalf of these families under public nuisance laws?
Well,
I would ask a clarification on that because I'm not familiar. Do you know what that?
I don't know what they're talking about. I'm not sure I'd have an answer for that one.
I would ask that T.Y. Prohl, if you could clarify that before we get off the air, just what do you mean by that? Because I don't understand how seek justice under public nuisance laws. What exactly you're going for there? Just refine that. If you can get it in, we're about to wrap. It doesn't. The 21-045 does raise an interesting question for me too, though, because and I'm assuming everything you were told was true, is that there was an amendment that was made to the law, right? And then, but the wrong version of the legislation got to Chief's desk, and then Chief does a veto based on what he has in front of him, and then they veto override that. So, wouldn't they need to do a whole new legislation to amend all that process? Because the wrong thing has gone all the way through the process. Would that be safe to say, or?
Well, I wondered about that too, but there's a provision in the law and in the rules that if you have clerical errors, I think they're attributing it to that.
I see.
And so because of that, they're saying that they could just replace the
I gotcha.
inaccurate version with the correct version, and
I see.
That's what they're basing it on. I was interested in how that would be corrected as well.
Okay.
I was wondering if they would amend it and take that part out, but they're doing it by a clerical error.
Gotcha. So,
Yeah.
As far as you know, just before we're almost out of time, as far as you know, you haven't been in contact with Chief's office if he's going to bring this into district court or anything like that. He hasn't notified you.
No, I'm not.
And then I wanted to say just before we got off, I appreciate all your hard work, sir. I know that because of all of the new cases that are coming in through the justice system, you guys are getting slammed, and I hope to see you again in the future. One of the things that I was trying to do with this particular stream is to try to get something out there for citizens who maybe can't get the legal opinion of the tribe all the time because of, just like you were saying, the disagreements between branches, etc. And if you're interested, I'd like to reach out to you maybe once every 2 months or every month or so. We could have a discussion about some of the legislations that's gone through that's related to what you're doing, and we could do this again sometime. And again, I appreciate you coming in today.
Okay, well, thank you for having me, Jared. I appreciate it.
Sure,
very
thanks.
much.
You've been listening to Mvskoke Radio. Join us again next week for more local, tribal, and community news and updates. But